Former Cabinet Minister Chishimba Kambwili has proposed an amendment to the Republican Constitution to provide for appeals to judgments of the Constitutional Court. Mr. Kambwili thinks that it is wrong for the Constitutional Court to be the first and last court to deal with issues of the Republican Constitution. He has contended that the current provision of the Constitution, where there is no recourse to appeal decisions of the Constitutional Court, is in fact against the norms of natural justice.
When we are making the Constitution, we must be very, very careful the way we make the Constitution, because the Constitution is the supreme law of the land. This lacuna in the Constitution must be sorted out. First and foremost, it is wrong for us to have the Constitution Court as the first and final court in deciding on matters of the constitutional issues, because there is no way, it is against the norms of national justice. When you go to court and you are not satisfied, there must be a letter of appeal. But you see, with the Constitutional Court, they are the first to hear the matter and they are the final court. Now, human beings being what they are, they can err and make mistakes. We made a mistake when we made this Constitution by creating a monster in the name of the Constitutional Court, which has no recourse to appeal. There must be recourse to appeal in every justice system. And there's no way we can say that the Constitutional Court is the first and final court on issues of the Constitution.
And Mr. Kambwili, who is among ministers and deputy ministers that stayed in office illegally after the dissolution of Parliament in 2016, has accepted to obey the decision of the Constitutional Court, ordering that the state be refunded what was accrued in salaries and allowances by the said individuals.
I am approaching this judgment in twofold. Okay. One is that I do not agree with the judgment of the Constitutional Court. Get me very clear. I do not agree with the judgment of the Constitutional Court. However, I am going to pay because I respect the decisions of the courts. Respecting the decision of the court and accepting the decision of the courts are two different things. What I'm saying is I do not accept or agree with their judgment, but I respect their judgment and I am going to pay as requested. The court has ruled, and I'm a law-abiding citizen, have to find the money and pay.
The former cabinet minister, who is also NDC leader, is further of the view the ruling of the Constitutional Court is not only embarrassing to the court itself, but to President Edgar Lungu himself.
The president represents the state. Any decision or action that he takes is for and on behalf of the state. And when he directed us ministers to remain in office, he was doing it for and on behalf of the state. Therefore, there is no way the same state that directed ministers to remain in office can ask him to pay back the state. That is illegal. That is illegal. And the person who should have been sued in this case should have been the president. And not to go and sue the ministers and ask them to pay back, because they did not remain in office. We did not remain in office in our own accord. We were directed by the state through the president. How then can the same state ask you to pay back? For me, this is an embarrassment to the president, and this is an embarrassment to the Constitutional Court.
On Monday, the Constitutional Court ruled that ministers and deputy ministers that held office after the dissolution of Parliament in 2016 refund the state what they accrued in salaries and allowances. Lazarus Sichula, Muvi TV News, Lusaka.